The petitioners in these petitions were employees of the Bank of Punjab, where they held senior positions while later dated 20 5 2009 and 12 8 2009. Their services were terminated in simpliciter. Through these constitutional petitions, the petitioners seek setting aside of their termination letters and reinstatement into service with all back benefits. These petitions have been contested by the respondents by way of a preliminary objection. They have taken the stance that the relationship between the parties is governed by the principle of master and servant. Therefore, the relief sought by the petitioners cannot be granted by this court in exercise of its extraordinary constitutional jurisdiction under Article 199 of Writ Petition number 24095 of 2009. In case the petitioners are aggrieved of any order passed by the respondent, their remedy lies in seeking damages from a court of plenary jurisdiction in view of the preliminary objection raised, which goes to the very heart of this controversy. I proposed to decide the same first. I have therefore directed the learned counsel for the parties to address arguments regarding maintainability of this petition and the preliminary objection raised by learned counsel for the respondents. The learned counsel for the respondent bank submits that this constitutional petition is not maintainable as the principle of master and servant is applicable to the relationship between the parties. He submits that service rules contained in the Human Rights Manual of the respondent bank are for internal use of the bank and are non-statutory in nature. Consequently, a constitutional petition is not maintainable. In this regard, reliance is placed on Abdul Wahab and others versus Pakistan Red Crescent Society, and another where it has been held that in case a service grievance is agitated by a person oblique employee who was writ petition number 24095 of 2009 by statutory rules of service before the High Court in terms of Article 199 of the Constitution, such petition shall not be maintainable. The learned counsel further submits that the petitioners was not dismissed on the allegation of misconduct. Therefore, the judgment of the Honorable Supreme Court of Pakistan passed in Civil Appeal number 39 of 2010 is not applicable to the facts and circumstances of the recent case. Full stop. The end.